My amendment project was on the Second Amendment. To understand the Second Amendment, I had to analyze it a little bit. The Second Amendment exactly is stated as a well-regulated militia being necessary to the security of a free state, the right of the people to bear arms shall not be infringed. A militia is a military force that is raised from the civil population to supplement a regular army in an emergency. And infringed means to break the terms of. So simply, the Second Amendment means a contained, controlled military force of citizens that is necessary for the security has the right to carry firearms, and it cannot be taken away. The Second Amendment was originally created to bring more power to militias to ward off the English. Many of those who were part of the founding generation believed governments were likely to use soldiers to oppress the people. English history proved that this risk was controlled by allowing government to raise armies only when needed to fight foreign conflicts. But for other uses such as invasions and emergencies, the government could rely on militias. Since 1791, militias are not common anymore, and militia organizations were eventually included into the federal military. Most Americans do not fear the nation's armed forces anymore, or think those forces could be defeated in battle. 18th century civilians kept at home the same weapons they would use if they were needed to serve in the militia, but modern soldiers are armed with significantly different weaponry than those of civilian use. Obviously, today, citizens no longer have firearms for militia use, rather to defend against common criminals. A Supreme Court case that is extremely relevant to the Second Amendment would be the District of Columbia versus Heller. So, in the District of Columbia, there was a law that banned handguns possession by making it a crime to carry an unregistered firearm and prohibiting the registration of a handgun. And in 2008, respondent Heller, a D.C. special policeman, applied to register a handgun he wished to keep at home, but the district refused. Heller filed a suit to urge the city from enforcing handgun registration, the licensing requirement to the extent that it does not allow the carrying of an unlicensed firearm in the home, and the trigger lock requirement to the extent of prohibiting the use of firearms in the home. The district court dismissed the suit, but Heller revised, stating the Second Amendment protects an individual's right to possess firearm and that the city's total ban on handguns, as well as its requirement that the firearms in the home be kept non-functional even when necessary for self-defense, violated that right. On June 26, 2008, the Supreme Court ruled in District of Columbia versus Heller that the Second Amendment does protect an individual's right to own and use guns for lawful purposes, including self-defense. The court also struck down parts of the gun law in Washington, D.C. that banned all handguns from the city and required that all guns kept in homes must be unloaded and disassembled or trigger-locked. A 5-4 majority ruled that the language and history of the Second Amendment showed that it protects a private right of individuals to have arms of their own, for their own defense, not a right of the states to maintain a militia.